The Illinois Supreme Court is considering whether healthcare workers' BIPA rights, the Biometric Information Privacy Act, whether their rights in the act are violated when they have to provide fingerprints to access medication in secure cabinets to administer to patients. It's an interesting case here, especially as the Supreme Court of Illinois previously has ruled in BIPA cases that could lead to some really large payouts from businesses. Well, how are hospitals being impacted by this? Welcome back to Springfield's Morning News. I'm Greg Bishop. You can follow me anywhere, Bishop on Air. Just search it out, BISHOPONAIR, on X, formerly known as Twitter, Facebook, YouTube. Just search Bishop on Air and you can find us that way. But let's go ahead and jump into this because you've got the Biometric Information Privacy Act that was passed in 2008. And we look at it now, not through the lens of what happened with, say, White Castle. If you're not familiar with that case, White Castle required employees to give their fingerprints to clock in and out. And the BIPA lawsuit was brought forward, and ultimately White Castle found liable. And then the Illinois Supreme Court came in, reviewed Illinois law, and said that each instance of a White Castle employee having to enter their fingerprints to clock in or to conduct other types of business within White Castle was an instance of infraction and therefore leading to possibly $1,000 per instance, which if you calculate that, that's billions of dollars of payouts that White Castle may be liable for. So that's still playing out. Whether or not they're ultimately going to have to pay that type of fine, we shall see. You've got business groups who have raised concern about BIPA and how it could lead to bankruptcy for a lot of businesses. I mean, we're talking about some business bankrupting settlements that could be possible if BIPA is not changed. So what about the healthcare industry? You see a lot of push to make sure that, certain types of medications like opioids aren't lost or stolen. So hospitals and medical companies have taken it upon themselves to create these cabinets where it's a locked cabinet and you have to enter a thumbprint in order to access the cabinet. And that's a way to try to keep these strong medications from getting out on the streets in an illicit manner. So you have that in place. But does that violate BIPA? Apparently somebody in a lawsuit making it all the way through to the Illinois Supreme Court and being heard yesterday. Here are the attorneys for the various hospital groups as defendants, Bonnie Delgado and Matthew Wolf. They lay out their case saying that BIPA has a HIPAA element to it where everything under HIPAA is carved out of BIPA. I know, HIPAA and BIPA. Earlier this week, we reviewed another Supreme Court case that dealt with FOIA and FOID, the intersection of FOIA, Freedom of Information Act request, and FOID, the Firearm Owner's Identification Card. So that was a separate case. Now we're looking at BIPA and HIPAA. So here is the attorneys, Bonnie Delgado and Matthew Wolf, laying out why they believe that they're in the right, having the safety of not being prosecuted for requiring nurses or others in the medical industry from accessing secure cabinets with their fingerprints.
Biometric identifiers do not include protected health information under HIPAA. Protected health information is the defined term under HIPAA for information protected by HIPAA. But that's not what our legislature said. If the legislature had intended to limit the healthcare exclusion to only information collected from a patient, the legislature could have ended this sentence at the end of the patient data exclusion. They could have simply said, biometric identifiers do not include information captured from a patient in a healthcare setting, period. But that's not what they said. The legislature gave us the very carefully and thoughtfully crafted healthcare exclusion that is not limited by the source of the information, but focuses on the purpose. The legislature used the word for healthcare treatment, payment, or operations. Healthcare providers' use of automated dispensing cabinets to access medications and medical supplies to treat patients is unquestionably healthcare treatment under HIPAA. As such, it falls squarely within this exclusion that the legislature has drafted for us.
Operations include patient safety activities. That is one of the examples given of operations in the HIPAA regulations. Treatment includes the provision, coordination, and management of healthcare. This is plainly healthcare treatment or operations. There's also a payment component for the tracking purpose, but we think it's very clearly healthcare treatment or operations.
So again, those are the attorneys representing the hospital groups being sued by staff who say that their BIPA rights are being violated. But they say that that's not the case because BIPA has HIPAA carved out of it. So they're trying to argue that HIPAA includes the operations of these healthcare industries, not just the information of the healthcare patients. So what do the plaintiffs have to say in this? James Zaris, he's representing those who are suing these hospital groups, and he's also been involved in the White Castle case. So he's an attorney representing plaintiffs who are pursuing these BIPA challenges. And he laid out why he thinks that the defendants are getting it wrong in this particular situation when they argue that HIPAA is carved out of BIPA, allowing for staff of hospitals to have to forfeit their BIPA rights.
If the defendant is correct, that means the General Assembly decided that as much as 10% of the Illinois workforce should have no biometric privacy protection whatsoever, simply by virtue of working in the healthcare field. The defendant's construction requires a very forced, unnatural reading of the plain text. And finally, the defendant's interpretation would leave workers without any biometric protection under this act, under HIPAA, or any other statute for no reason. Because, of course, HIPAA has nothing to do with worker data. HIPAA has nothing to do with the rights of employees or the duties of employers. The text, the structure, and the context of the statute as a whole lead us to the conclusion that this language here is intended to apply to patient data only. We agree the statutory language is very important, and we've talked about this. The critical modifier under HIPAA, ordinary meaning. First order of business in interpreting the statute. Well, what does that mean? Well, the only information that is ever under HIPAA is health-related patient information. There is no such thing as information under HIPAA that is not patient information. It does not exist. There is no dispute that the purpose of HIPAA is to protect patients. It is to protect their data. The purpose of HIPAA is to regulate healthcare, not globally, for any activities they may engage in, operations, treatment, and what have you. It is to regulate that industry, covered entities, when using patient data.
So again, the arguments pretty clearly laid out there by both sides of this. The Illinois Supreme Court has taken this case under advisement. It will be interesting to see how they rule BIPA is impacted by HIPAA. Are you confused yet? Hopefully not. Hopefully I spelled it out clearly enough for you. BIPA is the Biometric Information Privacy Act. HIPAA is the Healthcare Information Portability and Accountability Act. I had it right. All right. So yeah, HIPAA versus BIPA. Gotta love government and their acronyms. It is Springfield's Morning News on 92.7 WMAY. Springfield's News and Talk. And we'll update you whenever that ruling comes out of the Illinois Supreme Court, which still could be months away. All right, so stay with us on WMAY. And follow me anywhere. Bishop on Air. You can find it on X, on Facebook, on YouTube, or you can email me, bishoponair@gmail.com.